If you don't have a comprehensive estate plan, then your assets will need to go through probate. Probate is a court-supervised process in which your creditors are notified and all your debts and taxes are paid before your assets are distributed to your heirs. In addition, probate can take over a year to complete, and the costs and fees of probate are very high. By statute, an attorney's fees in California are based on the gross value of your assets. And with the price of homes in the Bay Area, often the probate fees and costs will exceed $50,000. I'm also constantly surprised at calls I get from people who think that because they have a will, they don't have to go through probate. Probate is literally designed for people who only have a will or who have no documents at all. So if you don't have a revocable living trust, you will go through probate. Some people avoid creating a trust because they think they're complicated, but they're not. A trust is really just a contract between you and the person designated as your trustee who will carry out your wishes. During your lifetime, the trust is revocable, and during your lifetime, as long as you have capacity, you are the trustees of your trust. You control all of your assets the same way you do right now with your checking or savings and all of your other assets. Because the trust is revocable, you can make changes to your trust throughout your lifetime as your life circumstances change. The reason we call it a revocable living trust is that it grows and lives with you as you go through life. A revocable trust should be the foundational document for any estate plan. But you also need other important legal documents. Those documents include a financial power of attorney and an advanced healthcare directive. Each of these documents are important and can protect you from ever having to have a conservatorship should you lose capacity. The financial power of attorney gives your agent the ability to pay your bills and make other financial decisions for you when you're not able to. The advanced healthcare directive similarly allows someone to make medical decisions for you. These are key documents to avoiding a conservatorship. A conservatorship is a court process where a conservator is appointed to pay your bills and manage your medical decisions. A conservatorship lasts for your entire lifetime, and there will be mandatory court accountings every 2 years, and those are very costly. And so avoiding a conservatorship is really important. The truth is that most people, by the time they reach age 75, will have one major medical event that could cause them to lose their capacity or become disabled, either temporarily or permanently. So it's very important to have a complete set of legal documents to provide full protection. Using a revocable living trust also gives you much greater flexibility than just a will. If you have a revocable trust, for example, you can decide at what age or ages your children will inherit your assets. For example, when you have young children, if you have a will and a tragedy were to occur, then the probate process will hold the money for your children until they reach age 18. Now, at age 18, most children are not really ready to manage large amounts of money. In fact, most of us hardly trust our children with $40 on a Saturday night, much less $400,000. So it's important to have a trust so that you can decide when you feel your children should inherit assets. In addition, there are special circumstances that can occur, and you might want to make changes throughout your lifetime about how those assets are distributed. For example, if a child became disabled later on, and you wanted to then create a further trust for that child for their entire lifetime, a revocable trust allows you to create that further trust for your child. A revocable trust also has what are called spendthrift provisions. These are to protect your assets from creditors if your children inherit them and they have an addiction problem, or if they have a gambling problem, or if they just have creditors. Another area where having a trust is important could be to protect your children in the event of a divorce. By maintaining assets in a trust for your children, they are separate and cannot end up being commingled and become part of the community property of the marriage. These are all important protections that you can get by using a trust and updating it over time. If you did your estate plan 20 years ago and you haven't looked at it recently, chances are the people you chose to be the successor trustees or agents in your power of attorney are no longer the right people for the job. Life happens. For example, I talk to people who have a trust they did when their children were young, and they have their parents as the successor trustees. But now their parents are in their 90s, and they aren't even the trustees of their own trust, much less capable of being the trustee for your trust. So you need to update those key players periodically so that your trust doesn't become stale. Another problem that I see regularly is someone who is inheriting money, but they have a disability and they're receiving public benefits. In other words, their parents created a trust 20 years ago and never updated it, but their child developed a disability and now should have had their assets go into a special needs trust or some other protection, but because the trust was never updated, that never happened. And the only way to avoid that, again, is to review your trust periodically and change as needed when circumstances change. At Feldman Law Group, we invite all of our estate planning clients to come in for a free review every 3 years. We always want our clients to be proactive so they can make changes they need to their estate plans before some emergency occurs.